Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we are talking about anti-Asian discrimination. Cases that should have gone to the Supreme Court of Canada, but didn't. In a case involving a dispute about equality rights in an administrative hearing, an individual argued that he was discriminated against on the basis of anti-Chinese racism. He argued that the tribunal should be aware of the circumstances of anti-Chinese racism in the same way that tribunals have been given direction from the Supreme Court of Canada and courts of appeal to be aware of circumstances related to discrimination against Indigenous people and against the Black community. And certainly anti-Asian discrimination has been on the rise in Canada over the last few years, particularly as a result of racist stereotypes that have come from the COVID-19 pandemic. And so shouldn't anti-Asian discrimination also be an issue about which courts and tribunals should take judicial notice? Shouldn't discrimination against anybody who is visibly a minority be something that tribunals should be able to take into account as a thing that they have notice of, that people are affected by? It seems to run contrary to the underlying principles allowing courts and tribunals to take judicial notice of other forms of discrimination against other visible minorities or other identifiable groups, but then to not say that a well-known problem with discrimination is also alive and well when it comes to anti-Asian hate. Unfortunately, the Supreme Court of Canada declined to hear this case, which raises an important question in and of itself of whether the Supreme Court of Canada is in fact implicitly endorsing that anti-Asian discrimination doesn't rise to the same level that discrimination against Indigenous communities or the Black community in Canada does, or whether the Supreme Court of Canada just didn't feel that this case was the right case for it. And that can leave a bad taste in a lot of people's mouths, suggesting that perhaps anti-Asian discrimination is not as extensive as the people who are the victims of it may feel that it is, and the way that we see that it is in our society. It's unfortunate that the Supreme Court of Canada didn't provide this opportunity to address how there might be a distinction between anti-Black or anti-Indigenous discrimination and anti-Asian discrimination in the legal system, or whether there isn't a distinction and that judicial notice should be taken of both. Hopefully, the Supreme Court of Canada doesn't have to hear another case involving allegations of anti-Asian discrimination, but ultimately, unless they do, this is not going to be an issue that's going to be addressed. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.